Good afternoon, everybody. Sorry to keep you waiting. Just waiting for a few more people to join because we did have a large volume of registrants. Otherwise, we will get underway. Just while we're waiting for everybody, I'll just go through some of the housekeeping, introducing myself as well. Just letting you know the information provided in the webinar is not to be taken as individual advice. It is general advice because no relationship, relationships come in all shapes and sizes, and there is no one fit for all. And also immigration law is consistently changing. So just be aware this is a general information session. The session is being recorded and will be sent by email next week. Questions can be submitted via the chat box. Also, I think the Q&A box too. During this webinar, we won't be sharing checklists or assessing your individual eligibility or discussing about your individual circumstances. For those of you who don't know me or are joining us for the first time for one of our webinars, my name's Julie Williams. I'm a registered migration agent, and I have been registered for the past 24 years now. So quite some time. I was the former national president and director for our professional body up until the end of last year when my tenure came up, but I was with them for 5 years. So lots of experience with partner visas in particular, and I'm going to be talking through with you today about the different options there are for partner visas, an overview of the partner visa process, eligibility, and there will be time for Q&A at the end of the session. So types of visas, there's always a lot. Partner, spouse, they are the same things. People wonder what a partner is, what a spouse is. Well, a partner and spouse are defined as either a de facto or married. It's not girlfriend or boyfriend or just sort of being in a relationship. It's actually living together in a committed de facto or married relationship. And that's what a partner and a spouse visa is. It's not for just your girlfriend or boyfriend that you might have been known each other and been hanging out together for a couple of years. But if you're not living together and haven't joined your household or financial commitments, then it's not considered to be a partner or a spouse visa. There is a few different options depending on whether you're here in Australia or whether you're overseas or your partner is overseas. If you're here in Australia, it's a subclass 820, combined 801. If you're offshore, it's referred to as a subclass 309, combined 100. They're both exactly the same, but one's lodged offshore, one's onshore. There have been some recent announcements to changes with the 309, and I'll just briefly outline that with you now. But also there is also the subclass 300 visa, and that's for people that are considering getting married and are unable to be together because maybe you're from or your partner's from a country where you can't easily facilitate a visitor visa to come into Australia, or your Australian partner can't live with you over there, or maybe there's religious, cultural reasons why you are not permitted or don't wish to live together before applying for this visa. Because the 820 and the 309 requires you to be living together in a committed de facto or married relationship. So the subclass 300 is also known as a prospective marriage visa, and it's for people that are considering getting married. You must have at least met each other once in person. It can't be just online, it has to be in person. And that visa will grant the person, I say there it's a 9-month visa grant. Traditionally and legally it is, but since the pandemic, they did extend it out to 15 months, and now they've reduced it back to 12 months. So it really is actually more of a 12-month grant, and you've got to show that you're going to get married within that validity of that visa. And then it allows you to come to Australia on that visa with full work rights, and just make sure that that is something you do wish to do and you do wish to get married. So it gives you a taste of living in Australia, and what life is like here. As I said, it gives you full work rights, multiple re-entry in and out of Australia. You must enter Australia first before you do get married on that visa. And the only thing it doesn't allow, it doesn't give you access to Medicare, where if you're lodging an onshore 820, it does give you access to Medicare, which for those of you who are offshore and not aware of what Medicare is, it's our national healthcare scheme. So the changes to subclass 309, during the pandemic, there were concessions for subclass 309 holders who found themselves here in Australia whilst they had lodged a 309 offshore. And you obviously have to be in Australia on a valid visa, whether that be a visitor visa, it might be a student visa, might be, any type of temporary visa that allows you to remain in Australia legally. Then it allowed you to remain here in Australia for the grant of the 309 as well, because the difference of the 309 and the 820 requires you to, the 309 is you are offshore at the time you are applying, and you must be offshore at the time of grant of the visa. For the 820, you are in Australia at the time of the application, and you must be in Australia at the time of the visa grant as well. But because the concessions were ending for the 309 that allowed people through the pandemic to remain in Australia for that 309 grant, they felt that it was quite unfair and there should be a more equitable playing field. So they've extended and made those concessions into a permanent arrangement as of November last year, and have allowed, and they've just recently sort of, even though they brought it in from November, they only recently announced it in the last week, that 309, people that have applied offshore for a 309 and find themselves here in Australia on another visa can actually remain in Australia for the visa grant. So you don't actually have to go offshore for that visa to be granted, which is great news. It also allows access to the Administrative Appeals Tribunal if the visa is refused, if there's a breakdown in relationship and the visa is refused, etc. It gives you a lot more rights that if you lodged an 820 onshore would have, because traditionally, previously, only the sponsor could appeal the decision on the 309, and now with the changes, it gives the applicant that right to appeal those decisions as well, which is good news. So the 309, 820 are all provisional visas until the grant of your more permanent visa, which is the 801 or the 100. So, and the fees are all the same for whether you're applying for the 309, for the 820 or the 300. If you are applying for the 300, then there is an additional step. So once you do get married, you're onshore, you've got to apply for the 820, and then the 820 requires an additional fee, but not the full fee all again. That second visa fee is $1,475. So just understanding the stages of relationship, and also I'm going to go into more depth too about the 309, 100, 820, 801 as well, and how that's a combined and a two-step process, but I'll be talking through that throughout the presentation today. So understanding stages of relationship, and as you're aware, Australia recognises same-sex partners. So whether you are a male couple, whether you're a male-female, or whether you're a female couple, you are all free to apply under either the de facto, the marriage, or the prospective marriage. So and then just understanding the stages of relationship. When you initially start dating, you might be boyfriend, girlfriend, or boyfriend, whatever the situation may be. But it doesn't necessarily mean that you're de facto. You may be staying over at each other's places, but again, it's not necessarily de facto. De facto is when you've actually committed to an exclusive relationship, and you are living together in a committed relationship. And it's exactly the same as a married relationship. The same type of evidence is required for de facto or married. And often when I'm speaking to people that want to apply for de facto, they're not understanding that differentiation between being in sort of a casual boyfriend-girlfriend relationship to that next level, de facto. So de facto, even though you might even be in a very committed relationship with your partner, you're not considered de facto if you're not actually living together on a permanent basis and you haven't sort of combined your household and your affairs together. You can still be considered de facto even if you are living together in perhaps a parent's home or something like that. Often that occurs here in Australia with rent very high and very difficult to find suitable rental properties. Some younger de facto couples and married couples tend to still live at the parents' home of the Australian citizen or permanent resident until they can afford to move out. So de facto relationship, I did again, it's joining your households. You've got to actually be living together and also joining your finances together, financial commitments. So you don't necessarily have to have a joint bank account. I understand that's not something done in this modern day. But they do need evidence of you sharing your financial responsibilities. So if you're renting, if you have a home, or maybe the Australian partner owns the home and you've moved in with them, how are you sharing the financial responsibilities? Who pays for what? And they want to see that there is an equal contribution or a commitment to that contribution. Sometimes it might not be that equal as far as paying 50-50 because one of you may be working, one of you may not be. Maybe one of you works and is in a higher paid job. It doesn't really matter. It just needs to show that there is some form of commitment that you're both sharing the responsibilities of your daily costs, such as your groceries, such as your rent, such as any utility bills. Perhaps you've bought new furniture, you've both shared the costs of that. You just have to be able to evidence that. And their other financial commitments might be that you've purchased maybe you've purchased a car together, or it doesn't need to be that big. Maybe it's a piece of furniture. You've listed each other as beneficiaries on your superannuation. Those are some of the financial commitments that you can show. So once again, you don't need to show a joint bank statement, but you do need to show how you share the financial responsibilities on a day-to-day basis. So the difference between marriage and de facto, a lot of people sort of go, oh, I'll go and get married because that will guarantee me the visa. No, it doesn't. The marriage certificate alone doesn't guarantee you that. So the only difference between a marriage and de facto relationship is a marriage certificate. You still need to provide all the same level of evidence. So who can apply for a partner visa? Somebody that is in a committed long-term relationship that is ongoing. It might not be that long-term. Maybe you've only known each other for a year, maybe less than a year, but you need to be able to show that the relationship is ongoing and you can support that with evidence of ongoing commitments. That might be future commitments. It could be as easy as some people have more higher commitments. They might have bought a house together, but it doesn't necessarily have to be that level of commitment. It could be that you're going overseas to spend time or visit the family of the applicant's family you haven't met. It may be something like that. Maybe you're committing to getting an animal together, a pet, a dog, a cat, what have you. Maybe you have future plans of going on a holiday together and you book that. It's showing future commitments. Maybe you're invited to an activity. It might be somebody else's wedding, a special birthday, something like that you've got future plans for. You do have to be over 18 years of age and you do have to pass the character criteria for the partner visa. It's like any visa, you do have to pass the character requirements. The other thing too being, I was just thinking of in a committed relationship, a lot of people may be engaged but not yet married, and they're applying under the de facto relationship. Be aware that you can't apply for both de facto and married. You can't sort of be in both camps. You've got to either commit to one or the other. You can be engaged, absolutely, but I don't recommend you sort of talking about the marriage if you're applying under the de facto relationship, because then the case officer would question your level of commitment and thinking, you know, you don't consider a de facto relationship to be, you know, just the same commitment level as marriage. Because if you're always talking about, oh, we're looking at getting married in the future and our future plans are to get married, well, hang on, you're already saying that you've committed to a de facto relationship. That should be sufficient enough. So just be aware that people do cross-reference that and do get confused. To apply for the visa, you do need a sponsor. That sponsor is your Australian partner. They can be an Australian citizen, they can be an Australian permanent resident, and they can be an eligible New Zealand citizen. Now, some people have been getting confused with what is an eligible New Zealand citizen. An eligible New Zealand citizen is somebody that has lived in Australia prior to February 2001. And so there's not that many people that are still left, because a lot of those New Zealand citizens have since become Australian citizens and hold dual citizenship. So if you're a New Zealand citizen that's only just recently arrived here in Australia or been here for the last 5 years or 15 years, unless you've been here since prior to 2001, then you're not considered eligible New Zealand citizen. So you must be a permanent resident or an Australian citizen, and only New Zealand citizens that have lived here prior to 2001 are considered permanent residents. Other New Zealand citizens have to have been an Australian citizen. You can't have previously sponsored someone within the last 5 years. And excuse me, sorry, I should have brought my cup of tea in. Talking too much, I beg your pardon. You can't have previously sponsored someone within the last 5 years unless there is excruciating circumstances, maybe that your previous partner passed away. There might be other exemptions there, but it's very difficult to sponsor somebody if you have already sponsored someone within the last 5 years. And also as a sponsor, you have to pass the character criteria. Some people might have an offence. It could be drink driving, it could be speeding, it could be something else, but the main part that they're looking at is making certain that you don't have any domestic violence charges, you don't have any charges involving children, things like that. So that's where you may not pass the character test there. They take domestic violence very seriously in Australia, and it's for the protection of the visa applicant, especially those that are from more vulnerable countries that may not have a fluent level of English and are not understanding their rights here. So as I briefly mentioned before, the partner visa process is a two-step process, unless you apply for the prospective marriage visa, which will end up being a three-step process. The two-step process, how that works is that if you have not lived together as a de facto or married couple for a minimum of 3 years at the time you apply for the visa, then what the Department of Home Affairs will do, they will assess your eligibility as being in a relationship and as a de facto or married couple. And if they consider that you are, but it's been less than 3 years, then they'll grant you either the 820 or the 309, dependent whether you're applying for an onshore or an offshore application. If you have been married or in a de facto relationship for a minimum of 3 years and can evidence that at the time of applying, then you will progress straight through to permanent residency and will be granted either the 801 or the 100, depending on whether you're applying offshore or onshore. If you do have to go through the two-step process, how that works, you will be granted the 820 or the 309. It gives you full work rights. It gives you access to Medicare. It gives you multiple re-entry, allowing you to travel in and out of Australia on that visa. And at the same time, it will give you full work rights as well. And then the eligibility for permanent residency is 2 years from when you lodged your initial visa. It's not when you get your initial 820 or 309 granted, it's when you lodge it. And at the moment, the partner visa processing is very quick. It's taking around 2 or 3 months for onshore. Offshore is a little bit different. It depends on the overseas location. Unfortunately, overseas offices such as New Delhi in India are very, very slow. Otherwise, most other countries do process it within a sort of an 8-10 month period if there's no additional concerns to your application. But permanent residency, they don't charge a second government fee for that second step, but it does require you to resubmit a new application applying on the grounds of your eligibility for permanent residency. And that can also be quite quick, but it also can be quite slow and can take up to 12 months because, especially if you're already in Australia, they consider, well, you've got your work rights, your access to Medicare, your multiple re-entries. So sadly, sometimes that second stage can be a little bit slower than the first. So the 4 pillars, they always refer to 4 pillars of a partner visa. They look at the nature of the household, the mutual commitment, as well as the financial aspects and the social aspects of the relationship. So let's look at the nature of the household. What they're looking at is that you share a home together, you live together and are not apart on a permanent basis. They understand people do have to be apart for certain reasons, sometimes traveling due to work. Maybe it's because someone needs to go back overseas, family commitment, etc. But it's not on a permanent basis that you are apart. They look at where you live, how you live, who else lives there as well, and how you share the responsibilities of the household, such as your housework, the payment of bills, things like that. Mutual commitment. What is your mutual commitment to one another? That may be that you've registered your relationship. That may be that you're married. That may be that you've got pets. That may be that you've got children. Maybe you've purchased a property. There's lots of different ways of expressing that. Maybe you've been in a long-term, long-distance relationship. You've had that commitment to one another to keep going until you are ready and eligible to apply for that visa. There's lots of things that you can have there. Financial aspects, I did touch on this briefly before, and that's sharing your financial expenses, how you share those financial responsibilities of day-to-day costs, such as groceries, such as bill payments, rental agreements. Maybe you've got a property, maybe one owns the property, maybe the other pays towards the utility bills. It's just it's not one sort of fits all. It's up to your individual circumstances. And as I say to everybody, don't try and fit yourself around a visa. Make the visa fit around you, and that's when you'll have a successful outcome. They also look at the social aspects of the relationship. That's often the easiest part. How you're accepted by family and friends. Are you accepted as a de facto married couple? Do they acknowledge that you are in a committed relationship? Therefore, you get invited to important events such as special birthdays, christenings, weddings, different events that you would have to be in a committed relationship for your partner to be invited in. And that's evidenced by, it could be photographic evidence, it could be statements from family and friends, all sorts of different things. So potential pitfalls. What can go wrong in a partner visa? A lot of people feel that just because they're married, or they may rush into a marriage, only knowing each other for a couple of months, that will secure them a partner visa. Sadly, it does not. I've seen many of people come to me that not understanding why they've had a refusal because they've been married, but they haven't provided evidence to show that they're in a committed relationship. So again, the registration certificate of a de facto relationship or the marriage certificate alone will not guarantee your partner visa approval. You need to meet all those 4 pillars that we spoke about. Not being able to evidence that you're in a genuine and committed relationship, that's also can be the downfall of many. They can't evidence and show that support of how they are in a relationship. Marry within a short period of time, knowing each other and not living together. Some people sort of get married and then they don't live together. But then again, there is an exception to that rule. Some cultures have arranged marriages where Australia is very accepting and aware of that. And the requirement is that they may have only known each other for a few months and they've got married quite quickly and then can't live together because either the applicant can't get a visa to travel to meet with to be with the Australian, or the Australian citizen resident can't travel over there because they've got work commitments. So there is ways around that. So we're up to questions. I know I sort of flew through that pretty quickly, and there's probably lots of different questions still. I have got a question here from Angel saying, I left Australia 7 years ago and I just have been granted a 155 resident return for 1 year. Can I sponsor my husband to go to Australia together? And you apply for 820. We've been together 14 years. Yes, so a lot of people that have got permanent residency have not lived in Australia for long, and you do have to have, and when you are granted permanent residency, you're issued with a resident return visa that's valid for 5 years. But if you haven't lived in Australia for 2 out of that 5 years, you get a 1-year resident return visa. So as long as you are the holder of that resident return visa, Angel, then yes, you can sponsor your husband and you can travel to Australia together. You can either lodge an offshore 309 visa, or you can, if your husband can gain a visitor visa with no restrictions of applying for an 820 whilst onshore, then you can certainly do that and lodge the 820. If you lodge an onshore application, you will get what's called Bridging Visa A issued to you, and that Bridging Visa A allows you to remain in Australia lawfully when the current visa you're on expires until the 820 visa is granted. And that Bridging Visa not only allows you to remain lawfully in Australia, it also gives you full work rights as well. So hopefully I have answered that question for you, Angel. Yeah. Any other questions? No. Look, I do want to thank you very much for joining today's session. We do have regular webinars. We haven't got any further scheduled at this point. Last week we did a general family migration where we included parents as well, and briefly touched on child visas. But we will have future webinars coming up, whether that be skilled migration, other areas. If there is a certain area that you'd like to learn more about, then you can certainly send us an email or give us a call and book a consultation with one of our talented registered migration agents. There is a number of us here, and we're all in-house, and there is a number of languages spoken in-house as well. So we look forward to be able to assist you further. If you want to keep up to date, you can subscribe to our newsletters and our social media channels. But thank you again for joining us, and I look forward to being of further assistance. Have a wonderful afternoon, everybody.